Oh, good afternoon, everybody, and welcome to the Samfiru Tumarkin live employment law show on Facebook and YouTube. My name is Sandy Chen. I'm an employment lawyer at our firm's Vancouver office. I practice in the field of employment law, disability law, and so I'm here for the next half an hour live, and I'll be answering any and all questions to do with employment law. So if you have anything, please just type it into the text box in front of you there, and I'll go in the order that I see them. So obviously, employment law covers a pretty wide variety of matters. To do with if you've been let go, if you're getting hired, if you're having issues at work with your boss, if you're being bullied and harassed in the workplace, human rights legislation. There's a wide range of issues that I come across. So if you're having any issues with employment, let me know. We can try to talk about it here. You can type in your questions if you want to talk to me privately. So if you don't want to discuss, your private matters on this public forum, please feel free. You can contact me. You can go to help@employmentlawyer.ca, or you can email me directly, and I'd be happy to chat with you privately about any employment law issues. So I had a few topics I wanted to talk about today, but I will put priority to the questions. So if I'm talking about something and you have a question, just type it in there. Feel free to interrupt, and I will put priority to the questions. We've got our first one today. Got a question from Murad. Murad is asking, can a specialist that was designated for me by Sun Life keep the report away from me and not give you the results? So Murad, I assume that Sun Life is the insurance company, and not an employer. If you want to give me a bit more details about your situation, I can help you try to answer that. But I assume that you may be on a medical leave, and you were sent to a specialist by Sun Life, which typically do disability insurance. So you can feel free to correct me or confirm if I'm correct. But I assume the specialist you were sent to was to do an assessment on your medical condition, and they probably produced a report. You do have a right to get this report. In fact, they should probably be sending it to your own treating physicians. If the report makes certain recommendations or certain diagnoses or opinions on your condition, and so if I'm correct in my assumptions and that's what you're referring to, then the answer is generally no. They can't keep the report away from you. You should get a copy of that report, and Sun Life, the person who did it, the specialist, barring some exceptional reasons, should be that copy of report should probably be provided to your own treating physicians. So Murad, if let me know if you want to follow up on your question or give me a bit more details. But I'm happy to come back to you in a bit. We're moving on to another question from Smoke, who's coming to us from YouTube. Smoke asks, what can you do if you feel that you are being discriminated against because of your race? Your pay is substantially lower than your coworkers. The only difference between us is race. So Smoke, that's a good question. And it's if the reason or if part of the reason that a company is paying less is because of your race, right? That's discrimination in, I'm fairly confident, all jurisdictions, at least in North America. Certainly in BC, under the Human Rights Code, you cannot do that, right? I'm sure most people know that's discrimination. What can you do about it? You can follow. Well, first of all, you can try to raise the issue with your employer to try to get your pay on par with other employees, right? There's legislation about pay transparency, some of it which has come into place already in BC, which protects you when you're asking about pay, right? About your own pay, about pay transparency. So you have legal protections if you're inquiring about your pay. The employer is not allowed to suspend you or demote you or terminate you because you wanted some pay transparency, right? So you can file a human rights complaint if your employer is not willing to, resolve the issue and put you on par with your colleagues. The issue of proving the discrimination is typically always, it's not an easy task. You basically, the employer in these types of cases will try to say, well, it's your qualifications, it's your experience, it's, this person's got more seniority. There could be a wider range of factors an employer can try to use to explain it away, right? So proving the case is different than merely, filing a human rights complaint. And so in your case, if say you're the only Asian person at this workplace and everybody else is white, and you are paid 75% of what everybody else is paid, and you have more experience, you have more seniority, you have a flawless performance record, no disciplinary records, then that could be something you use to prove discrimination, right? Now the company can try to come up with a valid explanation that has nothing to do with your race. I don't know what that may be, but certainly proving discrimination is it is a challenge sometimes. But you do have remedies, or you do have some courses of action you can take, and one of them is filing a human rights complaint. Okay, we got more questions. Anna is asking, you're injured at work, but your employer is not willing to help. So, and I guess your question in terms of maybe just give me a bit more details, but if you're injured at work and you have to go on a medical leave, right? You're allowed to do that. In most provinces, probably all provinces, certainly BC, if you're in BC, you have access to work-safe benefits, right? And that should compensate you for a certain percentage of your income. It's not 100%, but it's there's a formula for calculating your income loss, but there are benefits you can access through WorkSafe BC. If you're injured at work and you can still work somewhat, right, but you just need accommodations, so maybe you need to take a break, every hour. Maybe you need to just work part-time for a little bit while you recover. Under human rights legislation, Anna, you are entitled to accommodations for your injuries, right? And so if you want to give me a bit more specifics to your situation, and maybe don't go into the nature of the injury, but what do you mean by your employer is not willing to help, right? Are they just kind of saying, you can't do your job, so we're gonna have to let you go? Or are they saying, we're not going to support you for WorkSafe benefits? Or give me a bit more details if you can. So Murad, you're saying, yeah, you need to see me. Yeah, we're happy to chat. You can just go to our website. My email's on there. You can feel free to email me. We can chat privately. Okay, we got more questions here. Vote is asking, you were dismissed without cause. You were 35 years old. You worked there 19 months. They said they will pay termination pay, but they're not sure how much it will be. You were facing harassment by your boss and you were being bullied. So Vote, there's a few things I'll say about your situation. Number one, the issue of severance pay, right? The minimum for someone in BC that's been there 19 months is 2 weeks pay. That's mandated. That's the absolute minimum mandated under the Employment Standards Act. There's another concept called common law severance pay, which is typically a lot more than the minimums, right? Someone in your situation could get 3, 4, 5, or 6 months of pay, right? It depends on other factors like your position and how long it takes you to find a job. But typically, I would say for you, it'd be a few months. That's subject to some things like do you have like your employment contract? What does that say? But when you get your termination package, I would, if it's only 2 weeks that they're giving you, I would highly recommend that you get it reviewed by an employment lawyer and seeing if they can negotiate a better package. If you're in BC, come talk to me. But in terms of the bullying and harassment, that's obviously problematic and illegal under the law. If that's the reason they let you go, right, because you were being bullied and harassed and you made complaints about it, there's further courses of action you can take against the company, right? If you made a harassment bullying complaint against your boss and the next day you were fired, that's probably illegal retaliation under work-safe legislation in BC, right? It could also result in additional what's called aggravated or punitive damages for you through the court process, right? And so on top of severance pay, if you're being bullied and harassed every day and then they fired you because you made a complaint, that could subject the employer to additional penalties, right? And so whatever severance package they offer you, I would highly suggest you get it reviewed by an employment lawyer before you sign anything, right? Because once you sign, if they give you a piece of paper called a release, or if you sign something saying I accept this, that significantly will harm your or anybody's case, right? After you've agreed to a deal, it's difficult, not impossible, but it's difficult to back out of it. Another question got from Philip. Your employer was bought by another company. They told you this week that they're going to, that you may be required to sign a new contract soon. Do you have to sign it? So Philip, good question. It's a situation I've come across fairly often, and there's really no easy answer. So first of all, it depends on the nature of the transaction between the companies. So what I mean by that is there's something called a share purchase. There's something called an asset purchase. We don't need to get into that, but that's something that needs to be taken into account. The new contract, it's either with the same legal entity or with a different legal entity, right? If it's being bought by another company and they're getting you to sign a new contract, I assume that there's going to be some terms in there that may not as be favorable for you, right? One example is we're not going to recognize your length of service with the previous employer, right? Or another example is, if we ever have to let you go, your severance package will be minimal, right? Something along those lines. Or they could change your pay. They could change your hours of work. They could change your location. So you don't have to sign it, obviously, right? Nobody can force you to sign a contract. The issue is if you don't sign it, they may decide to just terminate your employment, right? The other issues, or the other main issue in this type of situation is if you are presented with a contract that's substantially similar to your previous contract and you reject it, there is a possibility you may not be able to actually claim for severance pay through your old employer. So Phil, there's a lot of considerations here, and there's a lot of cases similar to yours, not exactly the same, that that come before courts in the past. Some of it depends on the legalities of it. Some of it depends on your personal situation. And so I would say to you, you don't have to sign it, but there's implications, right? And I would suggest you take your contract and talk to a lawyer about it and give him or her the background of your situation and get some advice, right? Because there are implications of not signing it, and there are certainly implications of signing it. And it's hard for me, obviously, in this forum, it's hard for us to talk about in any meaningful way. Okay, I've got a question. Christine on Facebook. You transferred to the department 6 years ago. You work from home. They're asking you to do a hybrid model and come into the office 2 days a week. That's not possible due to your childcare reasons. What are your options? Yeah, so Christine, this situation has obviously become quite common. Well, since COVID and since COVID has kind of the restrictions have lifted in the last year or two. There's different categories of workers and there's different answers. In your situation, if you are working remotely before COVID, right, I'd say you have a strong case to argue that is a term of your employment by now, right? It might be explicit in your contract. That's something you'd have to look at. Or in your contract, it could say we can recall you to the office anytime at our discretion, right? Which legally entitles the employer to kind of call you back in the office when they can. So that first issue, it's unclear. We have to look at your contract but I mean, I would say if you've been working from home before COVID, it's possibly a term of your employment by now, and they can't just ask you to come back into the office, right? The second part of your situation raises the issue of accommodations under the Human Rights Code in BC, and in other provinces as well. But in BC, if you have childcare responsibilities, an employer has a duty to accommodate you, right? And so, if it's just not possible for you to go in because of childcare, you would have to, advise the company of that and seek an accommodation. And they would have to make an assessment whether it's possible and whether it would cause them, the legal term is undue hardship, right? But I think your options are, your first option is your first option should be go talk to an employment lawyer, come talk to me from BC, look at your employment contract, right? Figure out if you have a contractual right to work from home. And second of all, letting the employer know you have childcare responsibilities and asking for an accommodation, right? And if they unreasonably say no to your request for accommodation, you could seek help or make a complaint through the Human Rights Tribunal here. Okay, got more questions. So Philip, you're following up on your original question. You're saying you're an employee of 16 years. Okay, so you've been with them a very long time. You're worried that the new contract may have clauses that you could waive rights. And then you have a second question. So let's deal with this first one first. So yeah, so Philip, it probably does. In my experience, a written employment contract usually favors the employer, right? There will be terms in there, like I previously mentioned, about your, recognizing your seniority with the previous company. There might be restrictive covenants in there, such as non-compete. I don't know if that applies to you. There could be, like I mentioned previously, a termination clause that limits your severance, right? Because what could happen is if you sign this contract, which says if we have to let you go, we're going to give you the minimum severance possible, right? Something along those lines. They could let you go in a few months, and maybe you can only get like a week's severance pay or 2 weeks severance pay. So I mean, I think you're rightly concerned about the contract, and I would get it reviewed by an employment lawyer before you sign. You know, like I said before, you don't have to sign, but that has implications as well. But I think you should definitely get some sort of a review by an employment lawyer before you sign it or decide not to sign it. Second question you have not had a salary increases for years. Is that legal? Yeah, Phil. So it's, well, there's a difference between if you're unionized and non-unionized, right? If you're unionized, and your collective agreement says you get, a pay increase of X% or X amount for this period of time, or after 1 year, 2 years, that's a different story. I assume you're non-unionized, because if you're unionized, then the union would obviously, if they negotiated for a pay raise and people didn't get it, there would be a big fuss by now. So if you're non-unionized, there's no legal obligation on an employer to give you a pay increase, right? Most companies, I think, tend to at least try, maybe not every year, but maybe every other year, every few years, to give a cost of living increase, or some sort of merit increase just to keep people around. But legally speaking, they don't have an obligation to give you an increase every year, subject to the fact that obviously minimum wage laws, right, which have drastically increased in the last 2 years. So if you fall under that, then that's obviously illegal. But otherwise, unless you negotiate it for it, there's in your contract, there's no obligation on the employer to do it. Okay, we've got a few more questions. Arlene from Facebook is asking, can you still get severance pay if you were forced to quit due to pressure and bullying from a manager? After many HR complaints, nothing was done. So Arlene, the short answer to your question is yes, you can. My people who've seen me on this show a few times probably know this term. It's called a constructive dismissal. It's essentially it's conduct by an employer which forces you to quit, right? So you're saying you quit, but legally you've been terminated or constructively dismissed, right? So a toxic work environment, which is what your situation sounds like, will entitle an employee to quit and claim for severance pay, right? And maybe even compensation above severance pay for pain and suffering, right? It's one of those situations where a toxic work environment, you have to typically prove that it's become so bad that the only option left for you is to quit, right? In your case, it sounds like that. You filed HR complaints, and nothing's been done, and you're getting pressure and bullying and harassment from your manager, and what other option was left to you besides to quit, right? And so there's other situations as well of constructive dismissal, like if you get a 50% pay cuts unilaterally, if they move your job, your work location to somewhere geographically really far away, if they cut your hours of work, if they demote you, right, and embarrass you at work. There's a lot of cases where employees have successfully claimed for severance pay, even though they quit. Your situation sounds like one of them to me, and courts have recognized that an employee doesn't have to work in a toxic work environment, and they're entitled to quit and claim for severance pay if there's no other option left for them, right? Okay, more questions. Got one here from Rebecca. Rebecca, your husband's been told that his pay structure will change from commission and base salary to commission alone in the new year. This doesn't seem fair as commissions have no guarantee for stable income weekly. What can he do? Yeah, so Rebecca, this touches on the point I just made about constructive dismissal. Any change to the terms of your employment that the employer imposes on you unilaterally, right, and you don't agree to them, those are changes that could, depending on the degree, that could give you the option of quitting and suing for severance, right, through a constructive dismissal action. Your husband's situation could be a constructive dismissal, right? Because, well, I'm saying that because if the base salary was like $1,000 a year, right, and they're cutting that, and your total comp is $200,000, that may not be enough, right? If your base salary was $100,000, right, and your total comp was $200,000, that's 50% of your income potentially gone, right? And so it's a matter of degree. But yes, that certainly, your husband certainly could have a case for constructive dismissal. Before anybody considers quitting and claiming for severance, you should speak with an employment lawyer, because there are cases where employees have quit and sue for severance and they've lost, right? Those cases exist. And so you have to be very careful before you assert a claim of constructive dismissal and quit your job, right? Because typically you can't take that back. But in your situation, Rebecca, I mean, that's depending on the amount of the base and, percentage of how much the base is compared to total comp. And also depending on if they're going to make the commission structure more favorable, so as to assure a more stable income, right? Those are factors that are important to look at when you're trying to determine the options. But I mean, Rebecca, you can certainly reject the change, right? And in which case the company may terminate him and he'd be entitled to a severance package. So hopefully that answers your question. So I think I've gone through all the questions on my screen here. If anybody wants to follow up or shoot another question my way before I take off here, please do. For any of my viewers who are gig workers, so if you work for Uber Eats, like Skip the Dishes, I would encourage you to look at this update by the BC provincial governments, where they're planning on amending the Employment Standards Act to give you more protections. So there's a minimum wage that's going to be coming into place for gig workers in BC. There's other protections. Stay tuned, and that probably will be passed probably by the end of the year. But I will keep you updated. But I encourage you to look into it. It is new law that is coming our way in BC to help protect the employment rights of gig workers. Brandon, you're asking who qualifies as a gig worker? Uber drivers, Uber Eats, Skip the Dishes. I have to look at the exact definition of the new legislation, but I think it's called an online platinum worker or something. So I'm sure a significant portion of the working population here in BC. Okay, I've got time for two last questions here. Liz, you're asking, do you get a lawyer before disclosing to employer the employee position is constructive dismissal? Bold hint at having legal advice. Yeah, I mean, you can take that approach. It's not necessary in a lot of cases, because by the time you send that constructive dismissal email, you've already gotten legal advice, and your lawyer will probably help you draft that email saying, because of the actions you've taken, you've constructively dismissed my employment, right? So you can, but it's not necessary. But you should get a lawyer before you send an email claiming constructive dismissal, because certainly I've had situations where I've told people that it's a risky case, maybe don't pursue it. Right? That's the importance of getting legal advice to see if you actually have a valid claim. So Jordan, one last question: if you get booked for a shift to say unload a truck, company the size, there's still time to do other work, dismantling a deck. Is there something you need to do within your minimum hours, or can you refuse? What I mean is booked for a 4-hour minimum, truck was unloaded 45 minutes, and then they have this dismantled deck. So they're asking you to do something other than the tasks they assigned you to do. I mean, if it's within the scope and responsibilities of your job to dismantle a deck because you got the task done quickly, they can ask you to do that, right? Obviously, if dismantling a deck is not within your job description, then it's different. But there is a minimum they have to pay you if you're only there for 45 minutes. But it just depends on whether they can get you to do something else, depends on the scope of your job responsibilities. So I don't see anything wrong with that if it's in the scope of your job. Okay, you're saying it wasn't in the scope of your job. I guess if you feel like it's not in the scope of your job, you can tell them that. They might only pay you for the minimums. I think in BC it's like 2 or 3 hours. But if you're a laborer, right, or some sort of truck unloader, dismantling a deck, I don't know how related that is to your job description and specialty. But maybe come chat with me privately because we're out of time here. So Jordan, feel free to shoot me an email on the website. We can chat further. So thanks everybody for coming. I'll be back in 3 weeks. But I hope that everybody has a great weekend and that you guys found this helpful.